Okay. Hello, everyone, and thank you for joining this panel discussion. My name is Molesa Labina, Communications and Legal Officer for the International Commission of Jurists Africa Program. It gives me great pleasure to facilitate this conversation on internet shutdowns and human rights in Africa, featuring three illustrious panelists, and will be moderated by our incredible director for the Africa Program, Kajo Ramjathankio. I'll give the panelists an opportunity to introduce themselves in a little bit, and I think for now I'll just do a brief introduction by way of background. I will start off by saying that I'm very sad to share that ICJ Commissioner Jamasina King cannot join us for this discussion due to disruptions to the internet and ongoing protests in her native Sierra Leone. Our thoughts with the Commissioner during this time, as well as the Sierra Leonean people. But we hope that order will be restored soon. At least the internet has been, but we do hope that that the ongoing issues will be resolved very, very soon. Okay, then. So I'll just dive into a little bit of background about why we are having this discussion today. So this discussion marks the launch of our legal guidance on internet shutdowns and restrictions in Africa, which we as the ICJ published earlier this year. I think that Justice is trying to join again. There we go. So access to the internet is necessary for the realization of various human rights, including the right to freedom of expression, the right of access to information, as well as other related human rights. However, across the world, we have seen that the practice of internet shutdown for the purpose of suppressing these rights has been on the rise, especially during public emergencies such as the COVID-19 pandemic. And although it is a global phenomenon, the legal guidance is focused on the African continent specifically due to the severity of internet restrictions that we have in the region. So thus, this tool kind of aims to provide some direction on the legal standards to be adhered to when imposing internet restrictions, but with a specific focus on Africa. I'll allow the author of the guidance to give us a little bit more details on how this guidance came to be, but the discussion will also focus on the general impacts of internet shutdowns on the exercise of various human rights on the African continent. So those of you who are joining us via Facebook and YouTube, if you have any questions or comments, please do feel free to type them up in the comment section, and we'll do our best to address them at the end. Also, let us know where you're joining us from, what you do, and what your particular interest in this topic is. We'd love to hear from you. I'll now hand over to Kajol and the panelists to introduce themselves, starting with you, Kajol. Take it away.
Thank you, Melissa. Hello, everybody. Thank you for joining us. My name's Kajol Ramjathankio. I'm ICJ's Director for the Africa Program. I'm delighted to be here today discussing a very important issue around internet shutdowns and how this affects all of us. So looking forward to a great discussion. Thanks so much.
I think, Justice, you can go next.
Thank you very much, Melissa. Hello, everyone. My name is Justice Mavedzenge. I was privileged to be the lead author of the legal guidance, and I am the legal advisor at the ICJ.
Thanks very much, Justice. Felicia, please introduce yourself.
Hello, my name is Felicia Anthonio. I work with Access Now as the Keep It On campaign manager, and Keep It On is our global campaign against internet shutdowns. It's a pleasure to be here.
Thank you for joining us today. Mohammed?
Hi, everyone. I'm Mohamed Farahat. I'm Egyptian lawyer and legal researcher. Actually, I'm a member of the same committee of African Digital Rights Network. And by the way, I'm ex-ICJ 10 years ago with me in the program. Thank you.
Thank you very much, everybody, for those introductions. Kajol, I will now leave it in your hands to ask the panelists some questions.
Thanks, Melissa. I'm going to start with Justice. Justice, can you share with us how the internet has become such an essential space for exercising civil and political rights in Africa? And can you also give us an overview of the regional and international standards on the protection of internet freedoms?
Thanks, Kajol. So access to internet is it's indispensable for the realization of almost all the human rights. So it's I think while the discussion has been mainly centering on the relationship between access to internet and civil and political rights, I think the discussion should be broader than that. I think access to internet is the importance of access to internet to human rights is almost like the way oxygen is important for life, in the sense that there is without access to internet, it is not possible to exercise and realize a range of rights from civil and political to socio-economic. I think a case for a direct relationship between freedom of expression and access to internet has sufficiently been made and demonstrated. But I think the relationship goes beyond that. There is a direct relationship between access to internet and a whole range of socio-economic rights, including the right of access to livelihoods itself, the right to one's ability to trade, for instance, as a small-scale trader or even as a small-scale farmer, the ability to advertise produce, the ability to connect with customers and market your products is dependent on your ability to access internet. I think in places, in many of the countries that we work in, people use what is called electronic means of making payments. I'm not talking of the banking sector. I'm talking about things like M-Pesa, where in Kenya, for instance, or EcoCash in Zimbabwe, where you use mobile telephone for you to be able to make certain payments. Some of those mechanisms for making payments are dependent on access to internet, because there are apps that have been developed to make it easy and possible. And more efficient to make those payments. The point I'm trying to make is that there is a direct relationship between access to internet and a whole range of human rights, not just civil and political, but environmental, socio-economic, and so forth. That's the first thing. The second thing is obviously the fact that while this conversation is centering on Africa, but I think the importance of access to internet for the protection and realization of human rights is a global conversation, in the sense that all human beings, irrespective of where they are, they need to have access to internet as a leverage for them to be able to access and realize other human rights. Then I think your other question was on the regional and international standards. At the regional level, and obviously we're talking about Africa, the main instrument is the African Charter itself. And access to internet is an implied right under several human rights that are protected under the African Charter. I think one of them is the freedom of expression and access to information, which earlier on I said I think a clear case has been made in terms of the connection between those two. But remember, access to internet is implied as a right under a range of human rights that are protected under the African Charter. I think we also take into account decisions of regional tribunals, such as the ECOWAS Court of Justice. I think there are two important cases, groundbreaking cases, which continue to be referred to by the media and scholars on this particular subject. I think it's the case of, let me just quickly make a reference. It's the case of Amnesty International versus the Togolese Republic. I think another one is the Socio-Economic Rights and Accountability Project versus the Federal Republic of Nigeria, right? But what basically those decisions do is to interpret the relevant provisions of the African Charter and assert that access to internet is an implied right, especially under right of access to information, freedom of expression. But of course, I already made an argument earlier on that it's an implied right under several other human rights. Then there are interpretive instruments such as the Declaration on the Principles of Freedom of Expression and Access to Information, adopted by the African Commission, which makes a very clear case for access to internet as an implied right under. Access to internet is an implied right under access to information and freedom of expression. Then at the global level, the main instruments are the Universal Declaration of Human Rights. I think Article 19 is one of the most spoken about. The International Covenant on Civil and Political Rights, the International Covenant on Economic and Social and Cultural Rights. Access to internet is an implied right under a range of human rights that are protected and in those instruments. Of course, we have to also make reference to some of the general comments which have been produced as part of interpreting the different rights. I think the main one, which I think when this conversation about access to internet as a human right, when this discourse picked up, I think it was in 2011, it is the general comment number 34, where I think a direct connection between freedom of expression and access to information and access to internet was made. Then we also have to take into account the different reports of the special rapporteur. So that would sort of form the framework of the regional and international, the framework of sources for regional and international standards when it comes to access to internet as an implied human right, but also as a leverage for a whole range of fundamental rights.
Thank you, Justice. Now, Justice, would you mind walking us through how this legal guidance came to be and how it relates to your work at the ICJ?
So the legal guidance is an attempt to try and identify as well as discuss the main legal standards that are applicable when conversations around imposing restrictions on access to internet arise. And these standards, these substantive standards, are the principle of non-discrimination, principle of lawfulness, necessity and proportionality. And I think what the legal guidance does is to try and really zero in on these substantive standards and explain how they relate to the nature and scope of internet restrictions that are permissible under regional international human rights law. Of course, these are not new standards. I think that's one thing that we have to sort of remember. These are standards that are applicable in respect to assessing limitations on other human rights, including freedom of expression, access to information, and so forth and so forth. And these standards are actually recognized in some of the domestic constitutions on the continent, and have been thoroughly discussed, but in the context of other human rights. But what the legal guidance does is to discuss them in the context of access to information. Of access to internet. Sorry.
Thanks, Justice. That's very helpful. Could you expand on the purpose of the guidance, of the legal guidance, and explain to us who it was drafted or who it was intended for, And how can they make good use of the legal guidance?
So I think that relates with your with your previous question. Relates to your previous question as well. The guidance was essentially developed out of the realization that there's a need to deepen the conversation on the standards that are applicable when governments are imposing restrictions on access to internet, because this has become a very common phenomenon, not just in Africa. Of course, the legal guidance focuses on Africa, but the imposition of restrictions on access to internet is a global phenomenon. One could describe it as a global evil, if you want. So the intention was to try and identify these standards which governments must adhere to or comply with. Why? Because in many cases, these human rights are not absolute, right? They are not absolute. They are subject to limitations. But certain standards have to be respected when imposing these restrictions. And so the guidance offers, as its title suggests, it offers that guidance as to what these standards are. So who are the intended consumers or the intended audience? First and foremost is the general public, so that they know what their rights are in respect in respect to access to internet, and under what circumstances their rights may be interfered with, and to what extent those rights may be interfered with within the permissible framework of international human rights law. The second is the judges themselves, the courts, so that they know when they have petitions before them which challenge the legality or the validity of these restrictions, they know what standards are applicable in those cases. The other is policymakers themselves, because these restrictions are imposed by policymakers. So policymakers ought to be aware of what standards they need to comply with. Parliamentarians are also intended consumers, because these restrictions must be regulated through law. So what kind of laws should be put in place? Like the legal guidance provide guidance to parliamentarians for that. Then last but not least is civil society actors and human rights defenders themselves, as well as lawyers, because these are the stakeholders who have the responsibility to lead and support the public by asserting or enforcing or demanding the enforcement of these rights, by holding government accountable. So what the legal guidance does is to provide guidance to the lawyers, civil society, human rights defenders on what standards governments should be held accountable. Because you can't just say government should be accountable. You can't just say these restrictions are wrong, undesirable. You need to show why. What are the standards that you think have been transgressed or have been violated? So the legal guidance answers that question. So those are some of the categories of the audience who the legal guidance is supposed to assist.
In the guidance, Justice, you mention an ongoing trend across the African continent regarding the use of internet restrictions. Do you mind explaining this trend to us?
It's a very complex question, Kajo, because we have very limited time. But I think, in short, in many cases, including in Africa and around the globe, there is a tendency to impose restrictions as a way of suppressing dissent, or as a way of controlling the narrative or shielding governments from being held accountable. Because of that, you see that internet restrictions, including internet shutdowns, usually are imposed during specific times when citizens are holding government accountable, such as when there are protests. So I think an ongoing example would be in Sierra Leone yesterday, where there were mass protests, and then one of the responses from government was to throttle or to disrupt internet connectivity. I think in Zimbabwe we saw that in 2019 and in 2020. Then in 2021 we saw that in Eswatini with the anti-government protests. That they are not really anti-government protests. These are people who are protesting against specific policies of government. So when we saw that those protests taking place in Eswatini, government responded by switching off internet. So the trend is that whenever you have things like protests, or whenever you have episodes where citizens come together to demand accountability or to voice their displeasure with certain government policies, the response is to disrupt connectivity. But disruption of internet connectivity is also done as a way of resisting demand for transparency in order to ensure that abuse of power is hidden. So for instance, that internet we have had cases where internet connectivity has been disrupted in order to hide certain gross human rights violations, including in places such as, or including in times such as elections. I think the most recent one was in Uganda, where there were elections and then internet connectivity was disrupted in order to hide the violence that was going on against, mainly targeted against the opposition and human rights defenders. But of course, this is the trend that I'm talking about. I think it is also important for us to acknowledge that not all restrictions are imposed in order to prevent government from being held accountable or to suppress dissent. There are certain cases where restrictions are imposed for legitimate reasons, and I think we can have a conversation about that. But I think what the legal guidance tries to do is to provide guidance to policymakers, to judiciaries and lawyers on what permissible restrictions look like, what standards need to be complied with in order to ensure that restrictions are permissible, because there may as well be cases where restrictions are permissible, are necessary, but still they must remain proportionate. But if we want to talk about the trends that we have been seeing in Africa and across the globe, I think they suggest, the trend suggests the use of internet restrictions as a weapon to shield governments from being held accountable, as a weapon to hide abuse of power, corruption, and to also facilitate the stealing of elections and so forth. I think that's a trend that is suggested by, especially given that when these restrictions are imposed, Twitter was suspended indefinitely in Nigeria, and then I mentioned Uganda elections, I mentioned Zimbabwe, I mentioned Eswatini. In many of these cases, when these restrictions are imposed, there are no substantive justifiable reasons. Well, reasons are given, but there is no connection between the reasons and the evidence. In other words, I'm saying the reasons are not backed up with any credible evidence to show that these restrictions were necessary. But even so, these restrictions in many cases are disproportionate. For instance, you can't suspend social media indefinitely. There may be justifiable reasons why you must take that decision, but to then suspend, to then impose a suspension that is indefinite for an undefined period of time, that becomes disproportionate, and that then suggests that there are capricious ulterior motives behind the imposition of these restrictions. And that's why I suggested that there is a trend of using restrictions of access to internet as a weapon against political dissent.
Thanks, Justice. Of course, I'm noting that there were Kenyan elections 2 days ago, and I'm not aware that there were any internet disruptions, which is certainly positive trend. So, and with that, I'm going to move on to Felicia Anthonio. Felicia, welcome and thank you for joining us. You have been heading a campaign known as Keep It On with Access Now for some time. Please, can you explain to us and to the audience what the Keep It On campaign is about, as well as recent developments from the campaign, which focus on the African continent?
Thank you very much for the question. Okay, so Keep It On was started in 2016, and this is a global campaign against internet shutdowns. So in 2016, Access Now brought together a number of civil society organizations at our annual event called RightsCon, and we decided to launch the Keep It On campaign to end internet shutdowns. And at the time, and of course, this trend has continued over the years. Governments are increasingly resorting to internet shutdowns, as Alfred mentioned in his presentation, and mainly is to close the civic space as well as restrict freedoms of association, assembly, and expression. And so uniting under the Keep It On campaign, which is now made up of over 280 organizations worldwide, we have successfully fought internet shutdowns in several national contexts, while raising the profile of the issue at the international level. Successful in the sense that we've been able to raise awareness about shutdowns that are happening, documenting and following through, and holding authorities accountable through diverse strategies. Members of the Keep It On coalition work together to verify, identify, as well as document incidents of internet shutdowns. And we highlight also how these shutdowns impact fundamental human rights as well as daily lives of people around the globe. We work to also prevent their occurrence through advocacy. And for instance, you mentioned Kenya, and I think I will use this example to say that ahead of the Kenyan elections, a number of government authorities had indicated that the government was not going to shut down the internet. And so under the Keep It On campaign, we followed up on these commitments through an open letter to the authorities to hold them to their words. And as it stands, the internet was not disrupted during the elections. And we hope that Kenya will continue to be an example of countries that have not imposed internet shutdowns during important national events. We also build capacity of people, individuals, organizations on issues of shutdowns, as well as how they can advocate and also circumvent or keep themselves safe during an internet shutdown. And of course, strategic litigation is one of the ways that we push back against internet shutdowns. So what we define as an internet shutdown is an intentional disruption of the internet or electronic communication platforms, rendering them inaccessible or effectively unusable for a specific population or within a specific location. And it's often imposed to exert control over the flow of information. And over the years, we've seen that governments tend to shut down the internet using diverse ways, from complete internet shutdowns to bandwidth throttling or blocking specific communications channels like social media platforms across the region. What we've seen in Africa last year, we documented, that is Access Now and the Keep It On Coalition, we documented 19 incidents of shutdowns in 12 countries in Africa. A majority of these shutdowns occurred around elections and protests. We saw 7 election-related shutdowns in 6 countries, and these included Chad, the Republic of Congo, Niger, Uganda, and Zambia. And then it's important to note that this is, however, lower than what we documented in 2020, as there were 10 election-related shutdowns in 7 countries in the region. Around protests, countries like Burkina Faso, Chad, Eswatini, as was already mentioned, Niger and Sudan disrupted or entirely cut internet connectivity in order to quell protests in 2021. And then most governments tend to use internet shutdowns as a tool, not only to thwart and disarticulate the protest itself, but also to hide human rights violations that are commonly linked to security forces' crackdown on protesters, particularly in countries that have authoritarian regimes or weak democracies. And then sadly, countries that had not shut down the internet in the past, such as Niger, Burkina Faso, South Sudan, and Eswatini, per our shutdown tracker optimization project database, have now joined the list of countries that have imposed internet shutdowns in the region.
Thank you, Felicia. That was very interesting. Can you explain to us how internet shutdowns affect vulnerable groups, and in particular, how they affect women?
Yes, internet shutdowns affect all people, but then it affects marginalized or vulnerable groups even more. And this is because these groups are already facing some form of marginalization or discrimination, and internet shutdowns compound these problems for vulnerable groups. With regards to women, we are already in a region where we are struggling to close the gender digital divide. And so shutting down the internet means that denying women access to the already limited tools or platforms. For instance, men who are online are more likely to have what the Web Foundation calls meaningful connectivity than women who are online. We've also seen that more and more women around the world and in the region are setting up online businesses to fend for themselves and their families. And so once you shut down the internet, you are taking away this source of livelihood from them. For instance, in Uganda, where women operate small online businesses, a single internet shutdown can result in financial losses of up to 1 million Ugandan shillings, which is an equivalent of 280 US dollars, depending on its scale and scope. And then when you look at what taking you away from the region, women in India's Manipur region, for instance, don't just lose income during an internet shutdown, but rather it also has a severe impact on all aspects of their lives, affecting mental health, disrupting work-life balance, and limiting their ability to advocate on salient issues such as child trafficking and domestic violence. And then in many other countries, internet shutdowns have denied women access to primary source of essential information related to reproductive health. And because these topics are a taboo, including information about menstruation, breastfeeding, and childcare, pregnancy, as well as abortion. And then we have, of course, internet shutdowns robbing women of career opportunities, as well as interfering with their efforts to empower young girls and other women that take up challenging roles in the region and across the globe. So these are some of the ways that internet shutdowns do affect women and girls.
Thank you. Thank you so much for that, Felicia. In light of the recent decision by the ECOWAS court regarding the unlawful Twitter ban imposed by Nigeria, do you see a bigger role for regional human rights mechanisms on the African continent to hold governments accountable for internet shutdowns?
Yes, the landmark ruling by the ECOWAS courts is yet another win for fundamental rights and a warning to authorities in the region to stop imposing internet shutdowns. In the ECOWAS court ruling on July 14, it declared that the 7 months long ban on Twitter by the government was unlawful, and also required the government to ensure it does not repeat the same kind of censorship in the future. And this is the second time the ECOWAS court is passing a judgment around internet shutdowns. We saw its judgment in 2020 against the Togolese government for shutting down the internet, and it did pass similar ruling. And I think that the use of litigation is increasing in the region in response to shutdowns. We've seen countries, similar court cases, even though they were put forward before national courts in Sudan, Zimbabwe, Togo, and Zambia. And it's encouraging to see that civil society organizations are the ones leading and bringing forward these cases to hold their authorities accountable. So I think that they are important precedents. One might ask, despite all these rulings, we still have governments imposing internet shutdowns. But I think it's still important for us to acknowledge these rulings as precedents and as a way of seeing courts being actively involved in the fight against internet shutdowns. And I would say let's leverage these instruments that we have to hold governments accountable through the courts and other mechanisms that are available to us in the continent to bring an end to this growing threats to fundamental rights and freedoms.
Thanks, Felicia. And going forward, do you have any advice on how civil society organizations and activists can combat the growing use of internet shutdowns by African governments?
Yes, I think that the first one is that let's continue to name and shame perpetrators of internet shutdowns, and continued monitoring and documentation, because once we don't document and monitor these shutdowns, then it will be taken that they are not happening, and it's civil society that has the responsibility and the opportunity to raise awareness about these incidents as and when they happen. And I think also let's continue to collaborate and work in solidarity pushing back against internet shutdowns. One important recommendation I have is that we need to prepare and to plan ahead where it's possible. And so, for instance, under the Keep It On campaign, we have our election watch project, under which we, beginning of the year or prior to beginning of the year, we are able to compile the list of countries going to the polls in that particular year. And we identify what we call countries that are at risk of shutting down the internet. That is, have they shut down the internet in the past, or are the current digital rights developments in the country likely to trigger an internet shutdown? And then we work together with various stakeholders, including governments and civil society, to raise awareness and to engage with the authorities to keep it on, as I highlighted in the work that we did in Kenya. And then, of course, let's continue to use strategic litigation because it's one of the powerful tools that we still have available for us to use to push back against internet shutdowns.
Excellent. Thank you so much, Felicia. That was very, very helpful and very interesting, and really good advice for civil society organizations. We will move on to speak with Mohamed Farahat. Mohammed, please tell us more about your work as a digital rights consultant.
Great. Hi, everyone. As a digital rights consultant, I'm working with different networks in Africa about this issue. The first network I worked with, I started working with this still new network, and my colleague Felicia is also a member in this network. It's about digital rights in Africa. The main tasks or the mission of this network is focused on academic works to produce some research about related to digital rights in general. The last year we have two projects. One about the project to identify the landscape reports about the digital rights and how the legal tools used in Africa to close the civil space. And this is the first one. The first course is covered 10 countries. And also we have had another project about focus in surveillance law in 6 countries. Sudan, Egypt and Sudan was included in this, and other countries like Zimbabwe and Ethiopia, I think. And now we have a project. It's almost dead. It's focused on digital citizenship in Africa, and we still figure out another project to work in this within the network, the digital rights, the African digital rights network. And also I work with CIPESA in Africa. It's also focused in academic issue and have many activities. I work with also about project about data protection and privacy. Also, I was leader for research with one also new organization located in Ghana. It's about the digital rights hub, African digital rights hub. It's located in Ghana. We worked to design like the atlas about data protection laws in Africa. So I lead the researcher in this project. And I'm still working in digital issues, especially through my participation in different events and different forums like African Digital Rights, African Internet Governance Forum or Global Internet Governance Forum, through like proposing workshop related or focused mainly on digital rights in different issues, not specific issue, but the general umbrella is digital rights. So I proposed since 2017 until now. By the way, the first participation in internet governance issue or workshops, it was in 2017. It was, I think, it was in Geneva, and the workshop was about the internet shutdown in Africa. So this is first my participation in this issue. So I think this, in general, my work in digital rights.
Okay, great. Mohammed, you recently published an article on how digital inclusion is important for refugees. Can you explain to us how internet shutdowns and restrictions can affect refugees, and especially during the COVID-19 pandemic?
Okay, so let me to answer this question. We have to differentiate between two issues. One or depends on the module that the country, the host countries use to host the refugees, because we have different modules. For example, if we speak about like Egypt, because Egypt one of the countries who host many of refugees, we don't have the module of camps. We don't host refugees in camps. So the refugees when come to Egypt, they can live among the nationals, so they don't have problem. So if the government or any security agency takes that decision or practice to shut down the internet or to restrict the access to internet, of course the refugees will be affected by these measures. But when we come to the like other countries who like adopted another module to have a campus to host the refugees, I think there is also a problem, because according to the campus modules, the campus, especially in Africa, it always be located in the borders area or in very remote area. Maybe it's not covered. As Felicia, when she answered about the effect of shutdown on women, it's all the people who are affected, of course, because yeah, like if any country takes that decision to restrict access to internet, they will not exclude refugees. Of course, they will be included. And of course, according to the COVID-19, in some countries, because I know that in Africa or in North Africa, the situation of refugees is not good, and they cannot access to many of service like education, maybe healthcare, or but what's important also, they cannot access to call their families in another places in the country of origin. So the internet becomes the last resort to keep unified with their families. So if the internet is shut down or limited or restricted, I think they will lose this link between them and their families in other countries. But here, I would like or prefer to, to take the discussion to broad area, to another area. And I don't call that it's or claim it's the idea, but I think at this point I need to stress and to raise in this issue. Like if we call the definition of internet shutdown, what is the definition of internet shutdown? Is intentionally destruction of internet or limited or restricted access to internet. This is very clear. And also, as our colleague Felicia and Justice speak many times about the legal frameworks and international standards and international standards, so it's law. So I prefer to call this as de jure internet shutdown. This is de jure because we have internet, because to speak about the internet shutdown or restricted access to shutdown, so we need in advance that we have connectivity issues. We connected to internet. We have internet. So if we have internet, we are connected with internet. So in this time we can speak about internet shutdown or restricted access to internet. So and if government or any security agencies take action to restrict the access or entirely shut down the internet. So in this time we have evidence that we have like we know that these practices or these actions is totally contradict with international human rights law. But what the situation if? What is the situation if, especially in Africa, because I think the African continent is unique in this. If the government intentionally neglected to have the needed and required infrastructures in some places, is intentionally neglected that cause for based on, for example, for discrimination based on ethnicity, because this is one of the problem in all African countries, the ethnicity issue, and the discrimination based on the ethnicity issue. So in some countries we can find that the government, the regime there, intentionally neglect to have the infrastructure needed to internet in some places which belong to another initiative. So in this time, I prefer to call this the de facto internet shutdown. It's not de jure because there is no, but it's de facto. So we need to focus in this issue because as my colleague Justice mentioned that the internet is like oxygen now. It's like education, it's like housing, it's like healthcare. The government is responsible to provide this service and to protect, and or not protect, but at least to enable the citizen to access to this service. So, internet like education, now like healthcare, like oxygen, as Mr. Justice mentioned, it's like oxygen. But if the country, if the government or regimes intentionally neglected to have to enable this person who in remote areas or who are located in some locations belonging to another initiative, I think it's de facto internet shutdown. And we need to focus in this. Not only focus if the countries take action to restrict the access to internet or to entirely shut down the internet, but also I think if the countries intentionally neglected to have the infrastructure needed for access to internet in some places based on initiative or another issues as sort of discrimination against this group or this geographic area, I think it also should be included as de jure internet shutdown, not as de facto. So that in this time we can use like, but I like it because this repeated during this discussion about the importance of strategic litigation and using national courts. I think in this time we can hold the countries or the regimes accountability because they neglected to have the infrastructure in this issue in these areas or for this to prevent some specific groups to access to internet. And of course, restricted access to internet means we prevent them to access to knowledge, to education, to freedom of expression, and other range of rights, as my colleague Justice mentioned in the beginning.
Great, thank you, Mohammed. Mohammed, you're also the author of the Egypt Digital Rights Landscape Report for the Institute for Development Studies, a report on digital rights in closing civic space. Could you give us a brief overview of the current state of internet freedoms and digital rights in Egypt since the 2011 uprising, and also give us some indication of how civil society in Egypt has adapted to threats on civic space?
Okay, so to answer to this, I have to back to 2011, to the revolution, because why? Egypt is is the first country in the world using internet shutdown during this revolution, and after this incident, or because of this incident, this practice during the Egyptian revolution, this incident brought the attention of international organizations and UN agencies and all actors in this time to speak about internet shutdown. If you like remember or try to fresh your mind, you will find that the first time we speak about internet shutdown it's back to 2011 when Egyptian government shut down internet. So this one, Egypt is the remarkable milestone in this topic in internet shutdown. And of course, Egyptian government using the problem here, or not the problem, the issue here, the Egyptian government, the Egyptian regime in this time using the legal tools, and this is a problem. The using the legal tools to shut down the internet because it's based on the laws, and also this issue also to bring another issue. Not also we need to hold the regimes or the governments accountable for internet shutdown, but also service provider because government cannot shut down or to limit the access to internet without assistance from the service provider. Unfortunately, according to the Egyptian law, and this one, the provisions that Egyptian government used, that they have a right, they have a power as a government to ask the service provider to shut down the internet or to limit restrict the access to internet, and the government compensate the service provider. So in this time, service provider don't have any time. They in the end they will be compensated by the government. This is a problem. What happened after that? Our current situation. In Egypt, the current regime or previous regime after Mubarak regime, they didn't use shutdown as tools, but use another issue. What is now we don't witnesses entire internet shutdown in Egypt, but we have restrict access to some website or block some websites. That's it. This is the current situation. But in 2018, in 2018 and 2020, Egyptian government adopted, by the way, as other countries in Africa, adopted the laws related to the cyber crimes and data protection. And now the governments, different governments, use these tools, these legal tools, to restrict access to internet. Indirect way. How indirect way? To speak about the internet, access to internet should be trusted. Should be trusted access to not only access to internet. Because if I'm knowing from the beginning, if I using the internet, I have the access to internet, but I cannot interact, because if I know in advance, if I interact or post any post or publish any articles through internet, I will be targeted by the national security or the security agents. So I will be reclaimed to or prevent myself to be interact on internet. So I consider this indirect internet shutdown or indirect tools used by governments to restrict access to internet. So, as I mentioned again, the situation now in Egypt, okay, we don't have this. Recently, like we speak about 1 week ago, we have a new incident that the Egyptian government blocked one of media website. And in 2017, I remember, also Egyptian government used restrict access to around 500 websites and platforms, media platforms. This the current practice that in Egypt, not entire shutdown, but restrict access to internet. And also I need to, for Egypt, I also need to, in line with what Justice and Felicia speak about the strategic litigation and the importance of using the strategic litigation. After the Egyptian government in 2011 entire shut down the internet in Egypt, some of civil society and human rights activists in Egypt brought the case before the court to challenge this decision by government and ask for compensation. What happened in these cases? In the first stage, in the first court, the court mentioned that the Egyptian government in this time is accountable for compensation for other for the held accountability for international shutdown, and it's legalized, not legalized to entire shutdown internet in Egypt. This is the first. This is before the first court, the first residence court. The government challenged this order before the higher court. The higher court cancelled the first decision and mentioned that the Egyptian government in this time was in emergency. It's considered emergency time, and the Egyptian government has a right to entire shut down the internet to protect the national security, regardless of what happened. But what I think it's good for these cases, we have now two cases in Egypt, two decisions. One consider the internet shutdown is not legal issue, and the Egyptian government should have accountable for this. But another used the national security as a reason to cancel the one. And he mentioned that in the time of emergency, the Egyptian government or the governments, not Egyptian, but governments has the right to shut down. I think it's reasonable also. It's a reasonable issue also to mention that in as Justice mentioned, the human rights is not absolute. There is some limits. So I think it's the time of emergency. It's one of the limits that can force Egyptian government. And by the way, the Egyptian government like justified this decision because in this time there is some person, foreign person, come from border areas and come into Egypt, and they using weapons, and after that, and they involved in the revolution. So for that, they force it to shut down the internet. So also, it's a reasonable decision. So we need to like focus in the. I think so. Also, we need as Egyptian as civil society is they still working on this issue. But from my point of view, I think we need to focus in strategic litigation, not in national level, but in continental region, in African level. So, like during, I think one of the important issue to build the capacity of lawyers in Africa. How now? Okay, we have good experience and practice from ECOWAS and from another sub-regional from sub-regional courts, but we need to take this experience, this good experience, this good practice to be in the level of all countries, to be in regional, not in sub-regional level. So I think that to build the capacity of lawyers from all the countries in Africa about the digital rights or internet shutdown, or build their capacity about the strategic litigation. I think it will be good opportunity for all of us. Like for Egypt will bring this case of internet shutdown that happened during the revolution, and like my Felicia will bring another cases, and we can like discuss, exchange the information and techniques, what's the legal techniques each lawyers in each country to talk to reach to this good practice, or he managed to have a final decision that criminalize the internet shutdown.
Thank you so much, Mohammed, for that detailed overview of the situation. We've come to the end of the webinar. I understand that we have one question, so I'm going to hand over to Melissa to deal with the question and the comment.
Thanks, Kajal. Yeah, so if you do have any questions, I think now would be the perfect time to ask them quickly before we conclude finally. But we do have one question that's just come through on Facebook. I'll just display it now. And this is from Atef Ahmed. And he's asking, how do you see the high prices of accessing internet as a policy or tool of restricting or limiting internet, particularly for poor people in many African countries? And how can we solve that? I think it's a very interesting question. I don't know if one of the panelists would like to tackle it. Anyone in particular?
I can say few words because I from my point of view, high prices of accessing the internet is one of tools of indirect restrict access to internet, because the internet should be affordable for each one. I cannot say they like, if you would like to access the internet, you have to pay thousands of, or not tens of dollars to have the access for 1 minute. So I think if the can use these techniques to raise the price of access to internet, to restrict access to internet.
Justice, so Felicia, do you have anything that you want to add?
Yeah, I agree with Mohammed, and I think that that is why it's even more important that the little access we have should be protected by governments, and of course they have the responsibility to reduce the price so that each and everyone can come online, rather than imposing internet shutdowns that in the end take away the little access that people struggle to access anyway.
Thanks, Felicia. Justice, do you have anything else that you would like to add? Any concluding remarks you'd like to make?
I think Mohammed is very right. I think that was the gist of his presentation, actually, that there's a need to address or take into account the fact that there's a sizable part of the population that does not have the infrastructure for internet. The only thing I can just add is that there are different levels of obligations or types of obligations, rather, which arise from human rights. The first is the duty of government to respect, which really means the duty to refrain from interfering with those who are currently enjoying access to those rights. I think much of the debate on internet restrictions centers around the duty to respect. And there's a duty to protect, which is the duty to, protect those who currently enjoy access against arbitrary interference. But then there's another level, there's another type of a duty, which is the duty to fulfill, which is essentially the obligation of government to provide, or the duty to promote, which is the obligation of government to create an enabling environment. So as part of the duty to promote, and as part of the duty to provide or fulfill the different human rights that are enshrined in the Constitution or in the international instruments that we discussed, government has an obligation to establish or provide infrastructure to enable access to internet. So the question was, how can we solve that? I think we need to take action to, first and foremost, we need to spread the consciousness that government does not only have the duty to respect access to internet, but to also promote and fulfill through the adoption of policies. Without taking too much time, I was just thinking when the person who asked that question asked the question, you can actually, I was replacing the access to internet with something like education. So you can ask the same question and say, what can we do about the price for education? So what does the price for education mean what does the tuition for, or what we commonly refer to as school fees, right? What does the level of school fees mean for the right to education? The same question, what does the price for data and internet connectivity mean for freedom of expression? What does it mean for access to health? What does it mean for the right to food? What does it mean for the right to security and so forth? So that's really the question. And we need to focus, to answer that question, we need to focus on the duty to, the obligation of government to promote and to fulfill. And then from there, we'll then be able to then sort of identify the specific measures which government needs to put in place. The interesting thing, and I'm sure Mohammed might have discussed that in his paper, and access to now, you may also be engaging with these things on a daily basis. Felicia, I think many of these governments have actually have policies on which detail their intention to establish infrastructure for access to internet. But then the challenge is that these policies are never implemented, right? And the argument that they put in forward sometimes is that they don't have access to resources, right? But then the same way we have engaged with that argument in the context of the right to health, freedom of expression, access to the court, that's how we should engage with that argument in the context of access to internet. So that's what I would add. But Mohammed is extremely right what everything that he said in his main presentation, because I think it really touched on this particular. aspect.
Thanks very much for those remarks. We have, I think, one more question, and that's from Masakara. And she was asking, do you think that the guidelines should be used by the CSOs in their advocacy work, and where do we access them? So I have dropped the link to the guidance in on our Facebook page, so it should be in the comment section of this live video. And yes, just as I think you'd already mentioned, that civil society is one of the target groups for the guidance. Maybe you want to expand a little bit more on how they can use it, maybe a little bit further.
Not really. I don't think it's necessary because I've already explained that, and I think you've already answered that by making the link accessible. So I'm sure the online link to the guidance accessible.
Okay, wonderful. Okay, then I think that that concludes our discussion. Thank you very, very much, Justice Felicia and Mohammed, for your time, and thank you for sharing these valuable insights and giving us a very, I think, clear picture of the context that we're operating in and how the guidance can be a useful tool for policymakers, civil society, and legal professionals to be able to make good use of collaborating to better enhance freedom of expression, access to information, and realizing other human rights on the continent. I think you've given us some really great food for thought and given us some very valuable insights that will be useful for practitioners, academics alike. Kajal, would you like to add anything else and wrap up?
I would not. I just want to thank the presenters for joining us and to thank members of the audience for engaging with us with the questions and the comments. And please do go and read the guidance, and you're welcome to engage with us further once you've read the guidance.
Indeed.
Thank you
Thank
so
you very
much, and goodbye to you all.
Bye.
Bye.